This case opens with what looks like a routine courtroom proceeding, but within seconds, it starts unraveling into something far more complex. We're in a Texas courtroom, where the state is bringing charges against Chardonnay Leanne Lockhart. At first glance, it seems straightforward. Paperwork is reviewed, rights are explained, and the process moves forward like clockwork. But beneath that surface, there are cracks, small inconsistencies, confusion over charges, and questions that hint at a much deeper story. We're talking about a case that shifts from a serious felony, arson, down to a lesser charge of attempted arson. That alone raises eyebrows. Why the downgrade? What evidence led to that decision? And more importantly, what does that say about the strength of the case or the circumstances surrounding the defendant? Then comes the human element. As the judge starts digging, we learn about homelessness, conflicting statements, and eventually something even more significant: pregnancy, mental health concerns, and a life that seems to be spiraling under pressure. This isn't just about a fire. It's about instability, decision-making under stress, and a justice system trying to figure out how to respond. So here's the question you should keep in mind as we go through this. Is this a case of criminal intent, or someone in crisis who made a dangerous mistake? Stay with us, because what unfolds next is equal parts legal procedure and human drama, and every detail matters.
2 CR 3597, State of Texas versus Chardonnay Leanne Lockhart. Can I have parties announced for the record for the state? Defense.
Andrew Fred, Ms. Lockhart.
Are you Ms. Lockhart?
Yes.
Right. Counsel, have you received all the discovery and did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Ms. Lockhart, I'm showing you what's entitled Application for Deferred Adjudication or Community Supervision. Did you review that document with your attorney? Did you understand it and did you sign it?
Yes, Your Honor.
I'm going to show you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
I am a female. You keep saying yes, sir.
No, I said yes, Your Honor.
No, you said yes, sir.
I said yes, Your Honor.
I would
Okay.
say I heard yes, Your Honor, as well, Judge.
Okay. All right. Are you proceeding on the?
One moment.
Are you proceeding on the indictment as presented?
Judge, we're going to go with the lesser included offense of attempted arson, recklessly causing damage.
Okay. Any objection?
No objection.
All right, I'm going to show you what's entitled Court Admonishments. Did you review that with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
All right. Oh, you're right. She did say yes, Your Honor. I don't know why it sounded like sir. My allergies are really, I apologize. My allergies are really acting up today.
And Judge, I whispered to her that she needs to speak up and not say it. So no
Okay.
Right here, we see a subtle but important moment that actually says a lot about courtroom dynamics. The judge pauses over something as small as how the defendant responds. Yes, sir, versus yes, Your Honor. It might seem trivial, even a little awkward, but it reflects the court's emphasis on respect, clarity, and proper procedure. Interestingly, the judge quickly corrects herself and even apologizes, blaming allergies for mishearing. That's a rare moment of humility on the bench. But don't miss what's really happening underneath. The judge is paying very close attention. Every word, every response, every detail is being scrutinized. That level of attention becomes critical later when bigger inconsistencies come into play. So let me ask you, do you think these small interactions matter in shaping how a judge perceives a defendant? Because in many cases, credibility starts forming from moments exactly like this.
That's okay.
Thank you, Your Honor.
Because sometimes people always say that. And I'm like, all right. Did you understand the state is proceeding on the lesser included offense of attempted arson, recklessly causing damage as a state jail felony? The range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand?
Yes.
Actually, Judge.
I believe, Judge, since it's attempted, the arson, recklessly causing damage is a state jail, and since it's attempted, it's a Class A misdemeanor.
Okay. Why do you guys have this filled out as a state jail?
It should have been
The
changed.
first paragraph specifically should list it as a class. A.
All right, so you all need to redo this piece of paperwork.
Sure.
And I would suggest that you use the felony paperwork. That way you can write it in, because otherwise
It's difficult.
I don't have knowledge that she knows that it's a class A, because that's not how it's listed.
That first paragraph I wrote A right next to it. That's my handwriting. First page, Judge, it says range of punishment.
Now, this is where things start getting legally interesting. There's confusion over how the charge is classified, whether it's a state jail felony or a Class A misdemeanor. That's not a minor clerical issue. That's a huge difference in potential punishment. We're talking about the difference between jail time in a state facility versus a much lighter sentence range. The judge catches a discrepancy immediately, and this is a perfect example of judicial oversight in action. She refuses to proceed until the paperwork accurately reflects the charge. Why? Because the defendant must fully understand what she's pleading to. No gray areas, no assumptions. If that understanding isn't crystal clear, the entire plea could be challenged later. This moment highlights how critical precision is in the legal system. One incorrect line on a document can change everything. So here's something to think about. If the judge hadn't caught this, do you think the outcome could have been legally challenged down the road?
And it listed up to a $4,000 fine up to a year in jail.
Ah, okay, you are correct. Look at
Every
this.
once in a while, Judge.
Corrections are happening. I appreciate it.
I hate to correct you. Your
That's no. Here's the thing. I always tell people,
Sounds good.
make sure that if I'm saying something that's incorrect, to let me know. Okay. All right. So this is what I'm going to need you all to do, though.
Yes,
I
Judge.
need her to initial it so I know that she knows, because all of this is state jail felony paperwork. That's why I say
Well,
state jail.
Sorry about that, Judge. I saw that. I thought about using the other paperwork, but I didn't know if that was probably the better way. From now on, I'll probably try and do that.
Okay. Because all this paperwork is state jail felony paperwork.
I tried crossing out, it was the felony, the discussion about the felony, with the felony in possession of a firearm. And I thought I caught everything else. I think I changed everything to reflect
Yeah,
it.
we
Okay.
erased all of the stuff about the firearm possession because that doesn't apply because it's not a felony.
Okay, let me carefully read through the paperwork. Just give me a moment to make sure that everything is the way it should be.
As the plea process continues, the judge carefully walks the defendant through her rights. Jury trial, confrontation of witnesses, the right to remain silent. This is standard procedure, but it carries enormous weight. By accepting the plea deal, Lockhart is giving up all of those protections. What stands out here is how quickly it all happens. A few yes sir responses, and just like that, fundamental constitutional rights are waived. That's the reality of plea bargaining. It's efficient, but it can also feel incredibly fast-paced, especially for someone who may already be under stress or dealing with personal challenges. And let's not forget, the judge makes it clear that she doesn't have to follow the plea agreement. That's a powerful reminder that even when both sides agree, the final decision still rests with the court. So ask yourself, would you feel comfortable making a decision this big, this quickly, under these circumstances?
As arson as a Class A misdemeanor, the range of punishment for that offense is up to $4,000 fine and up to a year in Nevada County Jail. Do you understand?
Yes, Your Honor.
If you have a plea bargain agreement with the state, the court doesn't have to follow your plea. If for any reason the court doesn't follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, Your Honor.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, Your Honor.
And did you intend to give up those rights and enter into a plea in this case?
Yes, Your Honor.
It's to find you guilty. Court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Sure.
Anything you wish to say on behalf of your client?
That's the follow the mark.
All right, Ms. Lockhart, if you're released from custody, do you have a place to live?
Yes, Your Honor.
Where?
738 North.
No, I'm sorry, don't say the address,
Oh,
but who will you be living with?
I apologize. It's a property my father had bought.
Sorry, what?
I'll be living by myself.
Well, whose property is it?
My father.
Why were you not living with your father before? During this incident?
No, it's because I'm 30 years old.
Well, no, here's the thing. I'm reading this.
This is the turning point of the entire hearing. The judge starts asking about Lockhart's living situation, and suddenly, the narrative shifts. The police report suggests she was homeless, even stating that she started the fire to dry a blanket. But Lockhart denies being homeless, yet struggles to explain why she was living in a field with her belongings. This is where credibility becomes everything. The judge isn't just being curious. She's trying to assess risk, stability, and honesty. And when the answers don't line up, the tension in the courtroom rises immediately. Then comes the reveal: Lockhart is pregnant. That adds an entirely new layer to the case, emotionally and legally. Now, the court has to consider not just punishment, but rehabilitation, support, and the well-being of an unborn child. So, what do you think? Is the defendant being truthful here, or is she struggling to explain a complicated situation under pressure?
It appears, rightly or wrongly, the way I'm reading it, it appears that you were homeless. It says that you started this fire because you were trying to dry a blanket. So I'm wondering why you were not living. Well, no, that's what they say you told them. It's in the police report. So I'm trying to figure out, why were you homeless and why would your father let you live with him now?
Judge, if I can just have a second.
You need to be honest with me because I'm trying to figure out your conditions. And let me just tell you, one or two things are going to end up happening. If I don't believe you're going to be honest with me, this is going to be set for a PSI. You're going to be sent back to the Bear County Jail. They're going to do a PSI report, and I'll get it when I get it, which will probably be within 8 weeks. So you need to answer my questions, and you need to answer my questions honestly. Now, in this police report, basically it's implying that you were homeless because it said there were clothing and other items, and that you lit this fire because you told them you were trying to dry your blanket. So this is what you stipulated to. I didn't force anybody to stipulate to it. That's what's in the police report. So why were you homeless if now you can live with your father?
I wasn't at home, but I was not homeless.
So why were you living in this field or wherever it was with your items?
I have no idea. I don't know how to answer that.
All right. So why is she wearing yellow today?
I'm pregnant.
Okay. I just wanted to hear it. And how far along?
Like 21, 22 weeks now.
Okay.
Judge, I didn't mean to be presumptuous, but I have been in this court once or twice before. I did tell her she was going to be taking a parenting class, which was theoretically outside of it, but she understands she's going to take the parenting class going forward, because that's going to be her.
All right.
Now we're getting a clearer picture of what may have been happening behind the scenes. The defense mentions that Lockhart is now on medication and is more stable than she was at the time of the incident. That's a critical detail. It suggests that her actions may have been influenced by untreated mental health issues. The court begins to pivot from pure punishment towards structured intervention, mental health evaluations, parenting classes, and supervised programs. This is a classic example of the justice system trying to balance accountability with rehabilitation. But here's the challenge. These programs only work if the defendant fully engages with them. The court is essentially giving her an opportunity, but it comes with strict conditions and close monitoring. Let's be real for a second. Do you think systems like this actually help people turn their life around, or do they just delay the inevitable if deeper issues aren't addressed?
And is she on medications at the jail?
Yes, Judge. She was not on her medication at the time. Now she is on her medication. She's frankly alive. She's definitely competent at this point in time. At the time, she was not being rational, but at this time, she is going to be successful going forward. There is the part about the mental MIC caseload and her being interviewed for that. I believe that would be necessary. And she understands that being med compliant is going to be a part of that as well.
All right. Do you have any other children?
Yes, I do.
How many?
2.
And where are they?
Out of town with my family.
And what are their ages?
11.
They're both 11, twins?
Mhm.
That's either yes or no.
Yes.
All right, this is what, is there anything else from either side? Do you know if she's receiving SSI now?
I don't know.
All right, I'm gonna sentence you to 2 years deferred adjudication. I'm gonna want felony drug court referral. They should be able to do it because it's 2 years. And I'm gonna want a MIC evaluation. Those are to take place while in custody.
As the hearing wraps up,
And then I want to
the
order
judge delivers a
referral. If
structured
she's not
sentence.
approved to MIC, I want to
2 years of
referral
deferred
to
adjudication,
Center for
mandatory
Healthcare
evaluations,
Services,
community service, drug
parenting
testing, and strict
classes.
supervision. This isn't a light outcome, but it's not purely punitive either. It's designed to give Lockhart a chance to avoid a permanent conviction if she successfully completes the program. What's especially notable is the potential pathway to mental health court. If accepted and completed, this case could essentially be erased, as if it never happened. That's a powerful incentive, but also a significant responsibility. This case highlights the complexity of modern criminal justice, where mental health, personal circumstances, and legal accountability all collide. It raises tough questions. When should the system punish, and when should it rehabilitate? And how do we ensure fairness when someone's life situation is clearly unstable? If you found this case as shocking and thought-provoking as we did, make sure to hit that like button. Share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.
Take in consideration County Court Cause number 634806. 80 hours of community service restitution. Once she completes parenting, that will be satisfied. Regular reporting by Zoom or in person. Regular UAs. And I'm going to want a TAP evaluation in custody as well. If TAP recommends inpatient treatment, we'll start her with intensive outpatient treatment. And I'm going to want field visits 1 time per month until further notice. Probation will do proof of employment within 30 days of release, or proof of SSI within 30 days. There's to be no employment as a home health care provider or with minors. And I'm sorry, instead of the regular UA's probation, I'm going to want the UA hotline with testing at least once a week. Probation, is there anything else she needs?
No, Your Honor.
Is there anything else you need from the court to be successful?
No, Your Honor.
Counsel, do you think there's anything else your client needs?
There's nothing else she needs, Judge. We asked the evaluations be done when she's out in custody.
All right, that will be denied. I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it, and did you sign it?
Yes, yes,
All
Your
right,
Honor.
because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Right, yes, Your Honor.
All right, we can go off the record. Was she not approved for mental health court?
Honestly, can't tell you off the top of my head, Judge. Since she's been in custody this time, we've conferred with the DA, and this was the attempt. She's got quite a bit of time. So this is our agreement that we reached.
All right.
If she was approved, I know that she's being evaluated for mental at the MIC caseload, being that it's a misdemeanor, but mental health court, I don't think that was the approach, because there wasn't an option to be a misdemeanor until we talked about the last week.
All right, probation, can you also do a referral to the mental health court and see if they'll accept her? My understanding, mental health court, it's sort of like PTD. So if they accept her and she completes it, then this will be as though it never happened. So counsel, if they accept her in PTD and you all want to come back and ask for a motion for a new trial or withdraw her plea, then the court will consider that.
That's what I was thinking ahead, Judge. And that's why my brain was going like, I don't know if it looked like I was rolling my eyes. Does that mean that she wants? Yes. Okay.
All
I'll
right.
explain that.
So Rashawn, if you can, you're welcome. Rashawn, if you can make sure she's referred to mental health court and tell them that even though she's entered a plea here, if they're willing to accept her, defense is going to file a motion for new trial and the court will grant it. All right, thank you. You're welcome. Have a great day.
Thank you.
And I'll explain in a second what she's doing and really helping her out.
All right, and they'll put you back in the box so probation can speak with you, okay?
Yes, ma'am.
All right.
Thank you.
Please subscribe to help the channel.